Yes, welcome to the No State Project here live from the fortified compound in Mesa, Arizona. I am Mark Stevens. The channel is the No State Project, and we are streaming live again. We started the stream again every Monday and Wednesday at 7 o'clock Arizona time, and I guess that is, I think it's 10 o'clock on the East Coast. And so joining me like we did last week, we've got Calvin back. Welcome back, my friend.
That's right. It makes 10 p.m. Eastern Standard Time. Thanks for having me again, Mark. Glad to drop in for another episode of the No State Project.
Yeah, I got a great subject today, one of my favorites there. So if you're just filing in, you'll see on the channel there, we're talking about Socrates and improving our cross-examination skills. So I know we did a vegan ethics show last week, so hopefully the numbers reflected that. Which is really unfortunate because it's a great subject, but hey, I think we're all interested in talking about Socrates and the Socratic method, and so just a little bit about Plato, and I've just recently gotten really into back into the ancient Greek philosophers, especially the Stoics, but Socrates was always up there on the list, and Plato and. But Socrates, yeah, this guy, and he was canceled, wasn't he? Didn't they cancel him?
Yeah, he got a hard cancel.
Yeah, he had a hard cancel. So
cancel culture before it was a thing.
Yeah,
or maybe it always has been a thing. Who knows? Yeah,
you would think some people now think like getting canceled for certain things, or actually being murdered in his case. Is something that's new, and it's just something that you can ascribe to the is that stupid thing that they like to say, that rich a-hole, the woke mind virus. Did the woke mind virus, is that why Socrates wound up being executed?
Oh, I mean, I guess it could be reasoning. I guess could be woke to some.
Well, what I think is great was when in court, when DeSantis's government was in Florida was being sued, that the lawyers had to define what they meant by woke, and they were actually pretty close, that it was an awareness of social and racial injustice in the society, and wanting to correct that, which is, I think, pretty much on the money. It's like, what the hell is wrong with noticing that there are systemic social injustices? That's right, because you got the hardcore and anarcho-capitalist types that will just scream SJW, that any social injustice that an anarcho-capitalist points out, that's righteous. But if you're not an anarcho-capitalist, then you're just a woke mind virus infected social justice warrior.
Yeah, that's selective labeling. But, we've been fighting this fight, calling out the unfair justice system, the institutionalized slavery and the coercion that's unequally applied upon the most vulnerable people in our community for about 20 years on your show. And, some organizations have been doing it for a long time now, even longer than us. So, the fight has been out there, but, I guess it's new to some people now for some reason.
Yeah. Well, there's always going to be people who are going to disagree, and that's there was recently somebody. I want to just point this out. Somebody actually logged in, and I don't even know what promosum is. I don't understand that at all. I will have to look up this discussion with Lark and Rose. I'm not going to do it now, but yeah, you could just do a search for that. Yeah, someone here, so if you're watching the stream here, Shekel Collector commented, Hook knows queer. So, okay, gay? Good. All right, cool.
It's a little off topic.
Well, it had to, it wasn't even part of the stream that I did, or the video that I did regarding all this.
He super chatted you for that, for the for the readout.
Yeah, they should do a stream. Yeah, so if you, and since you mentioned,
you should be charging for that, Mark. I mean,
yeah. Yeah,
You can read that about yourself on air.
Yeah, that's true. But someone, this foreign source has gone kind of back and forth, and he's had some good discussions because there are people that are just way off the wall. But actually logging in to say you are getting much older, so I appreciate that. That's what 20 years. And before I even get, with the whole Socratic method is just asking questions, leading questions.
Yeah, I'm glad that you don't disagree with anything like that. I guess they must agree that you got all your bases covered there.
Well, I will point out that if you go through this, that put some age on me talking one goal the second time. That will accelerate the aging process like big time. But what really what was stressful and I'll be honest, boy, I tell you, when it came to doing those calls, that last couple of years, I really did what I could to push those things off. And if anything came up that I could cancel a call and do it on the next day, I took it, because dealing with those people, Calvin, I got to tell you, man, that's not healthy. It is not healthy dealing with tax agents, especially tax agents, every day or even 3 days a week.
Yeah, I can't imagine the cortisol that's been running through your system over the years.
It's,
more than anybody should be processing.
Yeah, so even though I did Adventures 20 years ago, I am actually only 26 years old. And so this gray hair, especially the sides, that's from just dealing with these tax agents. So here we've got the call to shame, May of 2014. That's and a tax call down here, call to shame tax predators, more lies from the IRS, American Terrorist Organization, another tax agent. So a lot of the call to shames were with tax agents, and a smaller number, though consistent, is we did have a lot of calls with actual prosecutors. And
that's right. The great thing about those calls too, to bring Socrates back into it, is one thing that I think influenced you is his way of asking better questions and more meaningful questions. And that really comes through on those calls of shame, where you kind of bring them back to the topic, because of course they try and straw man and dodge their way the state or do the State Department two-step or whatever they need to do to back out of the conversation. But thanks to the studying Socratic questioning, it's just entertaining to bring them back to task by asking the best questions possible. So hats off to Socrates for that one.
Yeah, and so Socrates, of course, was accused of impiety. Wow. A criminal charge in ancient Greece for the desecration and mockery of divine objects. Oh, so divine objects can take a little bit of mockery. Okay, so they're supposed to be they're supposed to be unbending truth and absolute. So irreverence towards the state gods. Well, a big big vafongul to the state gods, right? I can't help but join them on that, right? Disrespect towards parents and dead ancestors. Wow, what a charge. Corrupting the youth. After a trial that lasted a day, he was sentenced to death. He spent his last days in prison, refusing offers to help him escape. The Platonic Socrates lends his name to the concept of the Socratic method, also to the Socratic irony. The Socratic method, we'll just briefly here, is a form of cooperative argumentative dialogue between individuals based on asking and answering questions to stimulate critical thinking and to draw out ideas and underlying prepositions. It is named after the classical Greek philosopher Socrates. Socrates. And so this goes towards the burden of proof, which is in and out of court. And I believe that improving our questioning or cross-examining skills, it's not just when you're in court. It's something that you could use to possibly avoid going to court, which is what I talk about so much on the show, and the idea of cross-examination. So this is what's interesting here. I'm not going to play this because I'm not prepared for that. I don't know where exactly in this half-hour video it is, but I am quoting a Maine state tax supervisor, evidence the laws apply, and he does say it's assumed. I have that all through the call to shame where they will say it's assumed, right? You've heard that.
Oh, yeah, yeah.
So all I'm doing is, and again, we're trying to sharpen our rational thought process and engaging people. And when we're discussing something with somebody that has an opposing opinion or someone who's making an accusation, the mindset is to, for both sides of this, to come to a better understanding of the issues. So we have a better understanding of the facts and what those facts mean. And it's not just is this agent full of crap or not? Do they have the proof? That's a big goal. That's what we're trying to do. We're trying to limit the damage being done by bringing out that they don't have a case. And that's what we're asking the questions for. But it should always be a civil discourse with mutual respect, even if they're, like one I mentioned here is accusing me of yelling. That was a big one too. And staying professional and not sinking to their level. So they may raise their voice, they may be yelling, they may get irritated, they may be strawmanning or using dishonest tactics to avoid answering simple questions. We should, we should live honestly, injure no one, give every man his due. We should treat them at least with the respect that we think that we deserve. And when it gets to a point where they're not being, you may have to end the phone call or go up the chain of command. So this was one. I'm gonna have to play this on the. It's been 8 years. My gosh, May of 2014. Yeah, 8 years ago. Gonna have to maybe play, I'll have to preview that and pull out the part that I want to play here on the big show again. I heard that all the time.
Mark, when they say it's assumed, would it be proper to ask in response, are you assuming facts and evidence?
Sure.
I mean, because, right.
Well,
it's a factual dispute or a factual challenge. And when they say something that's, a factual challenge, that it's assumed, I mean, where's the facts in that? So it's.
Yeah. So we want to do, absolutely, is we're asking, we have the accusation and then we're asking for the facts that those are based on. And if it comes out that they say it's just assumed, well, obviously, a good follow-up question is, let me see if I understand you're saying that you're assuming material evidence. Or your accusation is not based on proof, but it's just an assumption. So you want to clarify, because, gosh, every single time they're going to come out, and when after it's done and the call is over and you file, say I do my follow-up paperwork, they're invariably going to say, that's not what I said. That's not what I talked about. That I think it was last week or the week before, where you did that record scratch on the one call with the Washington state attorney, county attorney, where she claimed at the end of the call, I never said that. Well, it's recorded. And what I always suggest doing is I always keep notes. See if I can.
I want to say also right now that it's also good to have on hand good analogies, so that when they assume facts not entered into evidence, it's good to have an analogy on hand so that you could put it in plain English, not only for them, but everyone else in the courtroom. Maybe a good analogy on what that would look like in another circumstance, and how absurd that is when you're actually asking for facts. It's very abusive when you're being forced to show up for court and being forced to pay money for things where there are no victims, there's no loss, injury, or harm, and they're wanting all of your, they want your resources, yet they won't at least provide the facts that they say they're required before all that can happen. So it's very bold of them to do that. But the more, and that was something that I kind of picked up from Jerry Spence. Anyone who reads through his books will learn really interesting techniques on how to argue better in court. And one of the things that he drives home is really driving a narrative with your story versus the narrative that the adversary is pushing. And obviously to ask better questions and use analogies so that the people in the jury or in the courtroom or the judge could really understand the absurdity of what they're saying. Because sometimes they say these things reflexively and out of just self-defense, not really even understanding what they're saying, just knowing that they have to say something because, of course, they're the Juris Doctorate in the room, and not having anything to say in response really kind of discredits their qualifications, and therefore they're going to have to respond somehow. And so I think a lot of these judges that respond like that may not even understand what they're saying when they say they assume it. But when you put it back to them, an analogy or just asking for clarification, I think becomes not only very obvious, but then and there you begin to exert their leverage that you're going to have in court to get your favorable outcome.
Yeah, another thing too is just feeding back the same words to them. So just in a more common political setting, to give an example of that, anytime a Republican is outraged at something, I mean, just frothing at the mouth, outraged, you just go, thoughts and prayers, dude. Thoughts and prayers. I got your back. Thoughts and prayers. You see how ridiculous that's done, when they're screaming about, oh, there's hardcore pornography in kindergarten. Oh, my gosh. Thoughts and prayers, my dude. Thoughts and prayers. You just feedback, or let's not politicize this. It's not a time it's too soon after the tragedy. Too soon. You just feed that crap right. And so it's the same thing, you could do the same there. Although it's a little different if we're talking to the judge. We're talking now about actually just cross-examining and improving our cross-examination skills. And because I can't do a full, I want to make sure I get this out before we're up against the clock there, because I can't do a full hour today. But I think, and you'll see, this is not new. I'm not making this up. I'm not saying that I originated this, because I didn't. But any half idiot knows the single most important thing that you and I can do to improve our cross-examination and questioning skills is one simple thing. Ask only leading questions. Right?
That's right.
And where did I get that from? You already mentioned his name. Jerry Mother Effin Spence.
He's the man.
Jerry Spence.
He wrote the book.
He literally wrote the books. The guy's never in his law firm, as far as he's never lost a criminal case. Ever. So the man knows how to cross-examine, and the first and last rule of cross-examination, ask leading questions. So just as kind of as a matter of instruction, what's a leading question as opposed to an open-ended question? Because the other end of it is an open-ended question. And a leading question is any question that requires just a yes or no. So these are going to be where we're providing the information to the witness or to whoever, like the tax agent, and they just have to answer yes or no.
In a courtroom setting, when you're asking a witness a leading question with a yes or no answer, and they go on to not reply with a simple yes or no, but another answer, like they'll either straw man or deviate in one way or another, what would a litigant do to bring that back in a courtroom setting?
Well, the obvious thing is to objection, move to strike, just and ask the judge and please instruct the witness to answer the question and not add anything to it.
I gotta say, Mark, I went to Ian Freeman's Crypto 6 trial for about 2 weeks, somewhere, maybe a little over, somewhere in that neighborhood. And the entire time of the trial, there were witnesses on the stand that were just meandering through the questions. And Mark Sisti, Ian's lawyer, was asking some leading, not all leading questions, but some leading questions, but allowed them to answer in a non-responsive way instead of just objecting. And I just kept thinking this during the hearing that, non-responsive yet, yes or no. Anyhow.
Yeah, well, that's really important. So let me ask you this. Was he asking this on cross-examination to a defense witness or a prosecution witness?
The examples are in both cases, as a matter of fact, but most critically in the prosecution witnesses.
Well, if you're letting a prosecutor, should just be leading questions on cross-examination, period. I mean, I believe that is, depending on the nature of the witness, how important the testimony is, it could be considered a reversible error if the judge because it can influence the jury. If the witness is allowed to, if I'm allowing the witness to have their verbal diarrhea and I'm asking a simple yes or no question, all right, so let's say they make a statement that X equals Y, and I ask for evidence that they rely on within their personal knowledge to prove that, and they don't answer the question, and they start shooting their mouth off. That could have an influence on the jury. That's really bad. I don't want that. So I would be objecting and moving to strike and instructing the witness, limit the answer to yes or no. You're not there to give a discourse. You're just there to answer the question. And and they're trying to derail they've probably been instructed to do that so that they could derail the cross-examination. And any lawyer or any litigant that allows their cross-examination to get derailed, if they're lawyers, they probably should be sanctioned for that. For allowing
so let me get
that.
this straight, Mark. That would be an appealable issue if Ian's lawyer, Mark Sisti, did not object to the non-responsive answers he was getting. They can bring that up on appeal.
I would argue, me personally, I'm not saying that Ian should do this or anybody else out there.
I'm just asking if that's an appealable issue in general. I mean,
my understanding of it is that would be an appealable issue for ineffective counsel.
Yeah,
it is cross-examination. Look, it's cross-examination 101. Okay, leading questions. You ask open-ended questions on cross-examination because you're directing it to go in a certain way. You're trying to, in a lot of cases, you're trying to show that the witness is not competent and not credible, and their testimony shouldn't be given any weight. And if you allow them to start spewing, they could say things that you're not expecting, things you're not prepared for, things you can't prove or disprove. So you got a problem. It's on direct examination. So whether the prosecution is calling up their witness or the defense is calling their witness, when the witness is first testifying, that's a direct examination, and their leading questions are not permitted except for limited, just to establish the purpose of the testimony of the witness, okay? But other than to establish the test, who they are and why they're testifying, leading questions are not allowed. I remember there was one, I did a Texas hearing. It was an administrative hearing with Yeoman that we won. And
nice.
Yeah. And 9 questions out of 10 were leading questions. And so even administratively, it doesn't matter that it's civil. You're not permitted to ask leading questions on a direct examination. So this is important. So just to clarify, the reason why is that the burden of proof, like I say here, the burden of proof is on the one making the claim. So when the prosecution puts their witness on, whether it's civil or criminal, when the plaintiff is putting their case on and they're calling their witnesses, they have the burden of establishing all the facts to show the cause of action. So they're not allowed, you're not permitted, due process and fairness does not allow the prosecution or the attorneys to influence in any way or as little as practical. My Long Island is spilling over again. They are not allowed to ask leading questions because the information is provided in the question for them to just say yes or no. And that can influence the testimony of the witness. So it's not permitted. So that's why Yeoman probably said objection leading 40 times. I mean, he was jumping in. All right, the man knows what a leading question is. He can take care of that. Leading. And almost every single time the administrating hearing officer, leading, please, no leading questions. Of course, it didn't stop the prosecutor, but that's what a leading question. A leading question is giving the information to the witness for them to say yes or no to. An open-ended question is after you went to the house. Well, what did you do on the day in question? Well, I drove my car to X's house. Okay, once you got to the house, what did you do? See, the information is not in the question. So a leading question would be, after you got to the house, did you approach the front door and knock on it? See, the information is in the question, and that influences the testimony of the witness, which is what we don't want.
Yeah, that's some good litigation cardio.
It's basic stuff. So the problem may be
it is basic stuff, but just like working out, Mark, if you don't have the muscle memory for it, if you don't role play this before going to court, it's really hard to make those objections and stay on your toes in court. Even though it is simple in practice, and maybe even in a role play, you could really knock through it. If you don't have that muscle memory, it's really hard to be effective in court. And I mean, how many train wrecks have we seen where people, and heck, I'll even throw my hat in the ring there. I've had a few train wrecks myself, not knowing when to make my objections or understanding just the basics in questioning. So even when it comes down to leading questions and open questions. So, yeah.
What I noticed in all these calls that we took on the show, all those calls were people reporting us what happened in court, and they're walking us through. Almost every time. Well, whenever they were questioning an agent, let's just say that in or out of court when they're questioning an agent or an attorney, the problem came in when they relieved the accuser of their burden of proof. Almost every single time. Almost every time. And that's why I've mentioned a lot since I started doing the stream again. Most of what I've done, and the reason why I have all these admissions from so many prosecutors and lawyers and agents from United States and Canada and Australia, is because I just focused and I wouldn't allow the burden of proof to shift to me.
And this is the burden of proof that cannot be assumed. Remember.
Well, hey, you can relieve the party of their burden of proof. I mean, even you could do that in court, and the judge, who's a state actor anyway, he's just going to let it happen. If you don't object to it and you don't catch it, what was the judge going to? It's just like what happened with James in Alaska. Nobody caught in the moment but me. But what was I going to do? I'm just watching this. The Tom Bradley, I think, was the U.S. attorney, called him a tax cheat in the middle of a trial. I even looked at the judge and the judge is like, someone has to say the magic word. And no one did. And so I read I gave it good to the two public defenders who were coming after me for not being a lawyer. I'm like, you just let your own client, you just let it go and have the prosecutor call him a tax cheat. Neither one of you had the common decency or integrity or just the competence to say, objection. You could have got a mistrial on that, on just that. But
yeah, you're assuming a whole lot when you call someone a tax cheat when they're supposed to be presumed innocent.
Well, but to draw a fine line there, the prosecution doesn't have to presume them innocent, but the prosecutor can't make such derogatory statements in a trial.
Right.
I mean, you can't get up there and say that the prosecution is engaged in child pornography. You got to have proof for one, and you don't just make such a bold statement in front of a jury. We have to make sure if I'm in or out of court, let's just stick with, look, someone's making an accusation against me. We're not even going to involve court. We're just going to talk about this in a theoretical sense. How do I improve my argumentation skills? How do I improve my questioning skills? And that comes down to you cannot relieve them of their burden of proof, at least until they meet it. And if you and this is something that happens all the time where people have reported, where they were allowed to not answer the question. This is why it's so important. I keep a record. It's not one of my old notebooks, but I couldn't. And anyway, it's been a while since I've done those calls. It's been 3 years. I keep a record, and I know exactly. I write them, down, and I know what I'm looking for. So if they don't answer the question, and anybody can go and listen to these calls. I know some of them are long, but if you listen to the questions, I have to qualify it. I almost never allow a non-responsive answer to go and just allow it. And if they try to engage me, of course, the John Buttrick one was a terrible interview, and I admit that. But most of the time, I didn't do that, and that's why you can see, and I have all the calls here. Well, almost all the calls, and then Rick on his channel has a lot more call of shames too. But you can see from all these calls why I was able to get the admissions that I was able to get. I mean, I don't know about you, but when a tax agent or somebody is making an accusation and their base claim is admitted to be assumed, whoa, I think that was effective questioning, right?
Yeah, if you can knock out a core element, a core foundation of their case,
yeah,
and compromise that, without that they can't move forward. Yeah, I think that's good leverage. Run,
and it's by their own admission that it's the foundation, and that's another thing you want to have them admit, that if they can't prove this claim, then nothing else is relevant. That base claim, that foundational claim, sets the relevance for everything else. That if this isn't true, nothing else matters. Well, you're not supposed to see. Oh, let's see how many comments do we get on this one? 59 comments. That's it. Well, 100 now. All right. What can you do? Well, look at all the hair I had. Well, look how black my hair was back in. You can't see it. I kind of.
Well, I gotta say, Mark, when was the last time you saw burden of proof trending on any social media? I mean, it's not going to be one of those barn fire shows.
Well, it's got a decent amount of views. It's for my show. Okay. It's got over 6,000 views. I mean, so it's got a lot of likes. But yeah, I understand it's a very small niche. I get it. Most people, unfortunately, like if you look at my subs, the majority of the subs that I have are not because of my show. They're because somebody else liked my show, who had a massive channel, who talked about conspiracies and secret government and the deep state and blood and all this. I never talked about stuff. I talked about things that you could prove. I have evidence here that could be replicated, where when you've got these massive channels that are talking about all this intrigue and conspiracies and deep state and whatnot, not a single thing can be proven, but it's intriguing. I wanted to stick with more, how can I improve my skills so that if I am attacked, I can adequately defend myself or effectively defend myself so these animals don't get nearly as much as they're trying to get. And if you go through and you do a search on my across the channel of tickets getting tossed out, there's plenty of evidence. There's plenty of evidence. I know. I always got to. There's always people that say, yeah, they were dismissed, but had nothing to do with you, Mark. Even
for the listener, if you go on the YouTube No State Project YouTube channel and just type in success for the channel search, you're going to see tons of videos come up. Yeah. I was surprised when I did it.
Well, I just did a search live here on the stream for tickets dismissed. And so the majority of the
success is even.
Yeah, there's pages of these, and sometimes there were multiple tickets that were tossed out. And I have the original documents in the video. Of course, I still have them, but I don't have a website. I have no money. But the original documents, the proof is in there. And so here's
explicitly granting the motion.
Explicitly granting the motion, but they turn around and say, well, the judge was just pissed off at the prosecutor. That may actually be true. But
well, I would be pissed off the prosecutor too if these guys went through law school, and if you can't prove a foundational element of your case, that should piss off any normal judge, I would think. I mean,
yeah, why are you filing in my court if you don't have the proof?
Right.
So the thing is, it may be true that the judge was pissed off at the prosecutor. But there's no proof of that. You can't actually, just because you worked in a prosecutor's office, you can't say, oh, you work for a prosecutor's office in Brooklyn, and I've got evidence here of a ticket being thrown out, and let's say, oh, this is St. Louis, not too far from your old stomping grounds. So how can you possibly say that the judge was pissed off, and that's why? That had nothing to, that he's going to sign off on a motion to dismiss, believing that the motion has no merit at all. That doesn't, you got to have actual proof, and here is the proof. And this proof here of all these tickets and whatnot. Oh, there's you. That's what we're talking about this last year. We're Libertopia. This is actual evidence. So, and this is evidence to show, and everything I did was always the same. And people called the show when they practiced their argumentation skills, they practiced their questioning, and they role played, and they did what they sharpened their skills so that they knew. And that's the easy thing here. Leading questions, it makes it so easy to know if you've got a responsive answer. It's only one of two things, right?
Was it yes or no or not?
It's yes or no. So it's one or the other. And so depending on what your line of questioning is going to dictate what you're going to say next. This is more than enough evidence. And so, like I've said before we wind up and I got to go, if anyone's going to make a judgment based on the material, do it based on the proof. So, we've got the Socratic method. We've got the burden of proof that they were using the Socratic method to keep the burden on the accuser. So it's like I've said here 1,000 times, the burden of proof is usually on the person who brings a claim in a dispute. The necessity of proof always lies with the person who lays charges. So that's all the questioning is being done. So when I was on the phone doing these calls and what became the call to shame, all I was doing was first get the accusation clear. I want to know exactly what the accusation is, and then I'm going to move to deconstruct it and see what actual proof, if any, that accusation is based on, and just by asking leading questions and not accepting non-responsive answers and the verbal diarrhea. And that's why not only have I had success with it, regardless of what these pseudo critics accuse me of, but how many other people have replicated it? I mean, you and I, we have it on here where we were at Jackalope. You came out for Jackalope in, I think, 16 or 17. And that's when Joe in Hawaii had possession charges thrown out.
Oh, yeah. Felony possession charges.
Yeah. And last thing here. So we see that this particular one, let me mute that. Oh, I had the intro for that. I didn't just talk about tickets getting tossed out. And so we had live calls. I don't have any money. I've never screened. And we've had people call with train wrecks all the time, right?
Yeah, it was an open forum. So we had, the successes along with the train wrecks. Right.
So I would put in the videos that this particular one was from only 4 years ago. Justin's ticket dismissed and Jackson's train wreck. So I have a number of videos where we had a ticket thrown out, but we also had to talk about the train wreck because I wanted it to be as real life. Look, this is not pretty. This is not fun. This is not, oh boy, I'm going to go and be a court activist. I'm going to purposely get it. This is ugly stuff. And it really took a psychological toll on me for all those years to be involved with these types of people. You're talking about people like Juan Galt every day for years at a time. That's all I did. It was horrible. What did I say? I said the show is an extension of what I'm doing during the week, right?
That's right.
And what I did during the week was really emotionally and mentally draining. It was.
I mean, it comes through, Mark. You don't have to persuade too many.
Yeah, it was.
It's tough. And anyone who's been in court, they would know. Yeah, I mean, you don't really have to say it's it really drains the soul out of you.
Yeah, yeah. And so if someone is an activist and wants to challenge things in court, hey, all the love to you. Just go into it with both eyes open and know it's ugly in there. It's really ugly. I mean, and if you're going to be spending a lot of time in there like Jermaine did, it's you probably change your mind after a while, I would imagine. I know.
And I like the advice that you had years ago on the show too, is that the objective is not to end up there in the first place. You know, do what you need to do to just, because once you engage in this, it's a loss already. It's best just to avoid doing what you need to do to avoid the issue. And the thing is, even by living peacefully and trying to avoid such circumstances, that's no guarantee, and hence why people should listen and learn to ask better questions using the Socratic method and holding the prosecutors to their burden of proof, something that they would agree upon, and certainly the judge would too. So what's the problem with that? And well, except for when they don't like what those answers are, but that's their problem, not ours.
Yeah, and just the last thing on this. I was wearing my SpongeBob shirt in that video. It was March 4th, 2020.
Nobody cares.
Try to keep it light. That was a different SpongeBob shirt, but I think it was is Mayonnaise an Instrument with Patrick, one of the greatest SpongeBob episodes with the Super Bowl. But just to summarize, to sharpen our questioning skills, to be a better cross-examiner, always leading questions, meaning it's just yes or no. Never, if you can help it. It's a little different in court. You're a little bit more prepared, as opposed to when you're just calling an agent and trying to get where they stand and maybe get them to drop it because they're just making assumptions. You don't want to ask questions you don't know the answer to. And that's why it's so much better to just take their accusation, write it down, and then just start asking questions on that, because it's very difficult for them to get away from that without you knowing and being able to rein it back in.
That's worth repeating, Mark, is never ask a question you don't already know, or at least are familiar with the answer to. That's very key.
Yeah. And that's another thing that catches. I would imagine that, even seasoned, attorneys, litigators, fall trap, occasionally that will happen also, because, hey, especially in a murder trial, in the heat of a questioning, something might come out. But if that's why we had the role playing, and the big thing was to keep people asking leading questions, stay on point, don't accept a non-responsive answer, because that'll derail you. The fastest way to have your cross-examination derailed, or your line of questioning, is to allow them to not be responsive. So,
and all that, along with don't ask questions you don't already know the answer to. So that's where having a script ahead of time really comes in handy, and the role playing.
Yep, it's a big one. It's a big one. Hey, I had a great discussion here. I appreciate it. For those interested, you could do an easy Google search or a DuckDuckGo. Do a search for Socrates. Get into more and read some of the of what we have on Socrates and the dialogues. Can't get enough of that great stuff. And there's tons of material on the burden of proof. And if you want some proof, you want to see how regular people like me and you, how we've done by defending ourselves, you can't get too better of a source of that than the No State Project channel here. You could do a quick search, and again, you can go through there's well over 100 videos just with tickets getting thrown out. So, here's one. 3 more charges kicked out. That's D.C. and England. 6 charges dismissed in New York, Indiana, Colorado. You name it, we got it over here. Well, I did a lot in California, so, yeah. Cool.
Yeah, didn't Jermaine have 5 charges from a mistrial dismissed, something like that? I mean, yeah, plenty of examples.
Yeah, and I just this is you and I in the that there. I just mentioned it. Jackalope.
Baca's Meadow. Yep.
Baca's Meadow. Oh, I have my Nobody for President shirt. You have it. Okay, yeah. So that's the yeah, beautiful. I might even try to get there again this year. It's been a while, but when did we do this? August 12th. 16? August 12th to 16.
Yep.
August 12th to 16. So you did come. Yeah, you came out, of course, and I think you came out the next year. So a lot of information. And Joe actually does call the show and give us a firsthand report on that. So yeah, a simple search should bring that up. So I appreciate you coming on. This was I had a great I think it was a great discussion. If anyone has any questions, if you're watching, let me know in the comments if you have any questions regarding sharpening your questioning skills, or if you have any experience using the Socratic method in court or against an agent. Let me know in the description, in the comments. And if you'd like to help support the show, the thanks button is there. We have the thanks button up there now, so don't be shy in using that so we can do more streams more frequently. So, Calvin, any last word?
If there's any topics that anyone out there in the audience wants us to cover and expand upon, definitely leave it in the comments. Let us know, and we'll do our best to kind of dig into it, especially if it's something that you think is going to help you out in court or just in general in life. Of course, we talk about veganism and health, and we shall return to those topics in a recurring manner. So anything that's on your mind that you think our takes might be helpful on, definitely drop us a line there.
Yeah, do that in the comments. Let us know. And we got to cut the stream there, but it's been a lot of fun. We'll be back Monday at 7 Arizona time, and again next Wednesday. So thanks, my friend. Appreciate it. And for everyone, appreciate you guys tuning in. And we will, until the